no professional should be improperly using AI. But right now in 2025, given the types of tools that are available for legal professionals and judges, I certainly wouldn't draw a bright line and say, don't use AI.
Generative AI has been public for about 3 years, but the tenet of US legal ethics are centuries old. So what happens when these two forces clash? Welcome to Clarity on Tech, a podcast powered by the Thomson Reuters Institute. I'm Zach Warren, the Institute's Technology and Innovation Insights lead. In each episode, we dive deep into the future of the legal, corporate, tax accounting and audit, and government communities. On today's episode, we dive into the intersection of technology and legal ethics, as AI raises big questions for client confidentiality, an attorney's duty of competence, reasonableness of legal fees, and more. Here's TRI's Rabia Butler to introduce Judge Maritza Braswell and Judge Lino Lipinsky, who explore these ethical questions and their potential consequences as we move forward into an AI world.
Welcome. The legal profession stands at a crossroads. As AI is rapidly transforming how we research, write, and even practice law, attorneys and judges alike are grappling with fundamental questions about responsibility, professional responsibility especially, client protection, and integrity over our justice system. As artificial intelligence continues to transform the landscape, professionals are facing a new wave of ethical challenges that threaten to upend traditional notions of competence, confidentiality, and candor. Today, I'm privileged to host an illuminating discussion between two distinguished members of the judiciary who are at the forefront of this critical discussion. United States Magistrate Judge Maritza Braswell and Colorado Court of Appeals Judge Lipinsky join us for what promises to be a thought-provoking exploration of where cutting-edge technology meets a centuries-old ethical principle as we continue courting change. With their unique perspectives from the bench, they offer insights into the complexities of AI and its impact on profession. Join us for this thought-provoking discussion that will leave you critically thinking about the future of law and the importance of ethics in an age of intellectual machines. Judges, how are you?
Really good.
Very well, thank you. Thank you for inviting me.
All right. Well, let's jump in. Judge Lipinski, I'm so excited to have this conversation with you. You and I talk every once in a while about this, and so I know how deeply you're thinking about these issues and how interested you are in these issues. So it's exciting for me to have this conversation with you. Let's launch right in. We don't have a lot of time, so I'm just going to launch right in. Maybe set the table for us and talk about kind of the key or what some might call primary ethical concerns that legal professionals should be sort of keeping at the forefront of their minds when thinking about AI. Just set the table for us.
Certainly. And Judge Braswell, it's always a pleasure to discuss AI with you. There are so many rules of professional conduct, so many ethical issues that are impacted when lawyers use and misuse AI. The first three that come to mind are the C's: confidence or competence, confidentiality, and the duty of candor to the tribunal. But AI affects other issues too. The duty to only assert meritorious claims and defenses, issues concerning bias. Many people don't realize of the risk of bias when you are generating outputs from an AI tool. And there is the interesting challenge of how AI is going to affect how judges determine whether billings are reasonable, whether an attorney spent a reasonable amount of time on a task, and then the attorney and the client seek to recover the time spent, the attorney's fee spent on that task.
I love how you sort of give that simple framework. There's so much to think about, right? I mean, I think as legal professionals are grappling with this, sometimes it feels like your head's sort of spinning, right? Because there's so much information to keep in mind. But I love how you put it really simply with the 3 C's. That's not to say that it's a simple issue, though, right? There's so much more to think about. But getting right down to it, from your perspective, and you think about the ethics rules with respect to AI a lot. From your perspective, would you say AI is prohibited? In other words, do the rules of professional conduct completely disallow an attorney from using AI, and so attorneys and legal professionals should just say, "Never mind, I'm not even jumping in those waters."
That's a great question, Judge Braswell. I would rephrase it slightly differently, which is whether the rules of professional conduct impact the improper use of AI. So no professional should be improperly using AI. But right now in 2025, given the types of tools that are available for legal professionals and judges, I certainly wouldn't draw a bright line and say, don't use AI. Lawyers throughout the country, throughout the world are using AI. They're using AI tools like CoCounsel from Thomson Reuters, and they're using some of the competitors' tools as well. So, way back, a long time ago in 2023, we learned by reading newspaper accounts about the Matta case, Matta v. Avianca, where a lawyer submitted a filing to a federal court. The filing contained AI generated hallucinations, fake citations. I think that was the first time that legal professionals around the country realized this was an issue. And at that time, there weren't the bespoke AI tools for lawyers like CoCounsel. Lawyers were beginning to experiment with AI. They were using ChatGPT, they were using similar tools, Claude and Gemini, but those tools weren't designed for the legal profession. And lawyers, like the lawyer for Mr. Matta, discovered to their embarrassment, to their chagrin, that their use of AI was generating these fake sites. So nowadays, fast forward 2 years, there are appropriate tools for lawyers, legal professionals, judges. And so we are now well down the road where folks in the legal profession are using AI. We're not going to go back. That genie's not going to go back into the bottle.
And that's one of the reasons I really appreciate talking with you about this topic and this technology, is because your approach is cautious, careful, responsible, understand the rules of professional conduct, make sure you're being ethical, but your message is never don't use these tools. And could it actually go the other way? Is there some increasing responsibility to engage with these tools, given that they are so prevalent now, they are so capable? How do you view that sort of potential obligation, whether it's now or in the future? Is there going to come a time where there's actually a problem with not using these tools?
We're beginning to see some judges and some commentators talk about how a lawyer needs to use AI to work efficiently. And there actually was an article written by a judge in Kentucky back in 2022 who said that judges who are considering attorney fee requests are going to start considering whether the attorney, the legal professional, spent a reasonable amount of time that could have been shortened if the lawyer, legal professional had used AI. So I'll give you an example. When I was in private practice, you could spend, say, 10 hours digesting a deposition. If it was a lengthy deposition and you were taking good notes and preparing a comprehensive summary of that deposition, maybe 10 hours would be appropriate. Well, I've seen demos of AI tools that can do that in a minute or two, if not in seconds. Of course, you have to check that output. But if you're filing a motion to recover attorney's fees, and the judge is going to look line by line at the attorney's billings, at the legal professional's billings, to determine whether a reasonable amount of time was spent on the task, the judges are going to begin to think, they may be thinking that now. I'm not a trial judge, I'm an appellate judge, but trial judges may start thinking, this task took too much time compared to how much time it would have taken had the legal professional used an AI resource.
Yeah. I think that's a great example, and there's going to be so many more like it. As a trial judge, I'm definitely it's at the forefront of my mind, right? How not only are lawyers, how efficient are they being, but their staff, of course, and even my own chambers, right? We have a lot of work, and so are there opportunities for efficiencies? Are there opportunities for us to move things forward in a way that expends fewer judicial resources and allows me to distribute those judicial resources elsewhere? So it's definitely top of mind, and I think very much in line with this conversation about our duties and our responsibilities. Um, Let's shift just slightly to talking about the ethical implications of using AI to prepare client communication. So, for those folks out there who are practitioners listening to this podcast, when they're preparing client communications or preparing confidential materials, what are the rules of professional conduct and the general duties and responsibilities they need to keep in mind?
Well, one of them is the duty to maintain client confidences. I think you and I were on the same panel. It was late 2023, and we were talking to the audience. It was an audience of lawyers to remind them or tell them for the first time that if you upload information to a tool like ChatGPT or Claude or Gemini, the information that you've uploaded may be used to train the tool in the future. You can't have any assurance that what you're uploading is going to remain confidential. And there was a lawyer all the way in the back who said, I get it. I understand it. However, I represent a company and the company's general counsel took my confidential memo and checked it by uploading it to ChatGPT. What do I do now? And you and I looked at each other. It's a little too late. So that raises a good question, which is not only should you be training your staff, if you're a judge, your clerks, if you're at a law firm, your associates, your paralegals, but maybe we need, if you're a practicing lawyer, maybe you need to talk to your clients too, so they don't inadvertently either waive the privilege or inadvertently make your work product publicly available by uploading it to a site like a tool like ChatGPT.
Right. And there are, I know that in some models, there's the ability to toggle whether or not toggle off the setting that essentially shares the information in a way that uses your inputs to train the model. But even then, I mean, once you've put it in there, even if you toggle that setting off and say, don't use this material to train your model, it's publicly available. I mean, these are open systems, right? And so you're uploading information and it's out there. Whether it's easily recoverable or not, I don't know. I haven't seen anything to suggest that it's a super, easy process to recover the information, but technically speaking or strictly speaking, it's publicly available, right?
Yes, it is. Back when I was on the e-discovery lecture circuit a number of years ago, we would talk about whether a lawyer could subpoena Facebook records and see what an adverse party had uploaded to Facebook. I haven't seen anyone talking about what if you serve a subpoena on ChatGPT and say, I want everything that Mr. So-and-so, a key witness on the other side of the case, has uploaded to ChatGPT. As I said, I haven't seen any writing on it, but it's a brave new world out
It's gonna
there,
happen at
and
some point, right?
it's going to happen at some point.
Yeah, I have recently seen some chatter around sort of the concept of sharing communications, right? So ChatGPT allows you to. There's a little button that says share my recent chat with so and so, and when you share it, it sounds like it gets indexed. And then once it's indexed, it's collected and potentially used in search results. And so there's sort of this other piece of it where it's already publicly available, but perhaps you're making it more accessible by sharing your communication with, for example, your client. And so it seems to me that as soon as we think we know we've got our arms wrapped around how these tools work, all of a sudden we hear something totally new that says, oh no, I hadn't thought about that, or oh no, I didn't realize that this was happening. How do practitioners, legal professionals, judges, how do folks stay on top of this stuff?
It is hard to stay on top. I try to stay on top of this because I speak and write on this, like you, quite frequently. But the example you give is so interesting. So this is a relatively new development. But let's say you're in court, it's the first day of trial, you have the names of all the potential jurors. Should you be sending a message to someone in your office? Oh, quick, check the ChatGPT uploads, filings, chats of these particular individuals. There was a case out of Missouri, I think it was about 15 years ago, fascinating case where case went to trial. It was, I think, a medical malpractice case, and the plaintiff loses. After the trial, by doing an internet search, a Google search, the plaintiff's lawyer discovered that one of the jurors had provided misinformation, had misrepresented a key fact, and that juror could have been stricken from the jury if the lawyer had only done that research at the beginning of the case. And the Missouri court said, well, you should have done it sooner, but this is a new rule. We're going to apply it uh, after this case. So, legal profession, you're on notice, but we are going to allow you to raise this issue and to move for a new trial. But think about all the information that's out there through sources like ChatGPT. It could concern a key witness on the other side of the case. It could concern a juror. So we are just beginning to scratch the surface of the information you can glean from these tools.
Right. And it raises so many interesting questions, like that hypothetical that you just shared, right? Because on the one hand, it's what types of responsibilities do we have? What ethical obligations do we have? One, to use the technology, right? If the technology is available, then do you have some affirmative obligation to do your due diligence in a different way than you might have had, a year ago or 2 years ago? And then also sort of what should be available and what should have some protections, knowing that there's so much information going, into the system. I mean, so many questions. And to your point, we're just starting to scratch the surface, but it's so important for folks to stay on top of it. And I think the way we stay on top of it is by having these discussions, right? And kind of unpacking it and thinking about these hypotheticals and trying to think ahead to what could be or what shouldn't be or what should be. And I don't know that we're having them enough. I feel like there's room to have so many more of these conversations.
So many more, and on a regular basis
On a regular
as the technology changes. As you know, the world of agentic AI is finally upon us. And imagine you're a lawyer, first day of trial, you ask not a human being, you ask your AI agent to scrape all the information you can about these prospective jurors. And then the AI tool does the work for you and reports back in seconds that, oh, this juror was a plaintiff in a medical malpractice case like yours,
Mm-hmm.
and you should raise this with the judge.
Mm-hmm. Yeah, yeah, and maybe that's a great use of it, right? Maybe this is a totally appropriate use. But at what point is there also going to be sort of considerations around who's responsible, especially when it comes to agentic AI, whether it's a lawyer using it or a company using it, right? Raises so many additional questions about where does the buck stop? Is it always the lawyer's responsibility? Is it somehow the third party contractor that the lawyer is contracting? I mean, from your perspective and from the rules of professional conduct, where does the buck stop? What do you view as sort of the ultimate bright line there when it comes to delegating responsibilities?
Now, the proverbial buck stops with the lawyer under the lawyer rules of professional conduct. But in terms of liability, to be determined.
Right.
The company that develops the AI agent may be liable if the AI agent breaks the law.
Mm-hmm.
But this is a whole new world.
Right. Right. And to your point, I mean, as professionals, legal professionals, we really have to keep in mind and be thoughtful about the rules of professional conduct, regardless of how the law is evolving on the liability side or with respect to companies or where the responsibility is. We're always going to have this professional responsibility, right, to ensure that whoever it is we're delegating to, whether it's some system, agentic AI or otherwise, or an associate who's potentially using AI, with or without your knowledge, right? That's the supervising lawyer's responsibility. And I know you talk about that a lot.
That's exactly right. Training is key. I've spoken to a number of law students, and they're all using these AI tools. For one thing, they have free access to them. So the law graduates these days, the newly minted JDs, are arriving at their jobs as law clerks or associates or in-house lawyers or DAs or public defenders, knowing how to use these tools. And they may not have been trained at the law school about the guardrails. And maybe they were, but I think every legal professional throughout our profession needs to make sure that everybody on the team knows what's appropriate, what shouldn't be done, what should be done. Because if someone who you supervise makes a horrendous mistake and say, prepares a memo to a client with hallucinations, or files a motion or brief with a judge, and that contains hallucinations, the supervising lawyer is ultimately responsible. So I think the checklist of orientation and training for new members of our profession is going to have to expand to include training on AI.
Yeah, I couldn't agree more. And I think, there is a tendency sometimes when the risk feels too great, when it feels a little too daunting to simply resort to prohibiting the use of it, right? To say, well, I'm just not going to allow it at all. And my thought on that is always one, even if you think you're prohibiting it, people are using it. I mean, to your point, they're getting used to it, right? They're already doing this in law school. It's everywhere. The use, numbers, the rates increase every month in terms of how many people are using these systems, whether it's in the legal profession or just generally. And so it's going to happen regardless of whether you quote unquote prohibit it or not. So isn't it better to have some clear use policies and some clear directives and, to your point, clear training on it versus just blanket prohibition?
You can't stop. As I said, you can't put the genie back in the bottle,
Yeah.
and you can't go back in time to the pre-AI world. I've been practicing long enough to remember having a case where the law firm on the other side was probably the last law firm in the state of Colorado that didn't use email. And all of a sudden, the courts start requiring use of email for e-filings and communications from the court. And they didn't want to adopt email, but the courts forced them to start using email. I'm sure their clients pressured them as well.
Right.
But you can't say, no, this technology is too scary. There's too much to learn. I don't know if I'll make a mistake. Unfortunately, with AI, we are well past that point.
Yeah, I agree. And this also feels similar to the sort of movement to cloud-based systems, right? Where for a while it was sort of a, well, we can't do that. Could it potentially create all these confidentiality issues? And, how are we really going to make sure that it's not, there aren't breaches? But after a while, it was sort of, well, if you're not using a cloud-based system and you're not backing up in that way, you're potentially risking loss of sensitive information. So eventually it sort of became the standard. And I think we're on our way there when it comes to some of these tools, especially some of the tools that are, to your point, becoming sort of bespoke for the legal profession. Would you agree with that?
I would totally agree. And also, under the duty of competence, in particular, comment 8, which talks about competence in terms of technology, as you adopt new technology, you've got to be competent in it.
Mm-hmm.
So lawyers who began working with cloud storage companies needed to think about things like, what happens if this company goes belly up? Do I get my data back? There were some lawyers who worked with some uh, less professional companies, shall we say, that didn't have a strong track record and that failed. And all of a sudden, the lawyers realized one morning, the company's gone belly up. The company has failed. They had all my data. They had all my law firm data in the cloud. Where is it? And those lawyers were in a world of hurt because they couldn't access their files.
Yeah. Going back to the comment you made earlier about the hallucinations, obviously it feels like we're seeing some news story on that regularly now, right? There's some
We are. We are.
lawyer that's being sanctioned for the hallucinations. What are you seeing in terms of the types of consequences? So just kind of thinking about what's out there, what's been happening. What should a lawyer expect if they are caught with hallucinations in their brief? What does it range from, and how bad can those sanctions be?
The judges, I think, are beginning to lose patience with the lawyers who haven't read the various articles, who aren't keeping up with the technology, and who are continuing to file motions, briefs, other documents with the court that contain hallucinations. So we're seeing disqualification, we're seeing monetary sanctions, we're seeing references to disciplinary authorities. I wrote the first opinion in Colorado, and it's all of 7 months ago, but it seems like years ago, on what a judge should do, what a court should do if a self-represented litigant files a document with the court that contains hallucinations. Now, interestingly, in that case, the Al-Hamim case, I sent out the order to show cause. What are these citations? Where did you get them? Send us the cases. In that case, the self-represented litigant showed considerable candor. And in his response to our order said, yes, I used AI and I apologize. So in that opinion, we concluded we were not going to impose sanctions against this individual, but we ended the opinion by saying, from this point forward, the legal profession and litigants are on notice that the courts may subject them to sanctions if they submit filings with these fake sites. And I think the sanctions generally are becoming more serious.
Yeah. Yeah. Do you worry a little bit about the sort of chilling effect that has on, because on the other side of that coin is kind of the access to justice piece, right? The idea that pro se litigants perhaps will have increased access to justice because they are able to use some of these tools, and and to see that they are potentially, subject to sanctions. Could that have a chilling effect on their ability to say, "Yeah, I'm gonna leverage these tools as best I can"? Or do you think it'll all sort of even out, and in the end, it'll still allow these pro se litigants to access these tools, but just do it more cautiously because of these types of warnings?
Um, I really don't think many self-represented litigants read the opinions of our court as much as I would hope they do. So I think we are going to continue to see these filings containing hallucinations in cases involving self-represented litigants.
Mhm.
And I think judges do have to be conscious of the access to justice issues. Um, So the self-represented litigants who are using what I call the mass market tools,
Mhm. Right.
ChatGPT and Claude, Gemini, they run the risk of uh, obtaining outputs that contain hallucinations. But there are now what I call the bespoke legal resources like CoCounsel. Lexis has their version, Lexis Plus AI, but we don't make them available to self-represented litigants. So I've spoken to some law librarians and I asked, could we make some of these tools available so a member of the public who has a legal issue could come in and could use a generative AI tool for free using one of these legal tools. And it's very unlikely, not impossible, I suppose, but it's unlikely. If you use one of these legal tools, you will get a reliable output that doesn't contain hallucinations.
Mm.
And the response I got was, we can't do that because you need to be trained to use them. So it is a frustrating dilemma
Mhm.
because we don't want untrained people to be using the legal generative AI tools. So what will they do? They'll go back to the chat GPTs. And I don't fault chat GPT. It wasn't designed for legal research.
Right.
I spoke to one of the developers at Anthropic, the developer of Claude, and he said, we didn't design this for legal research and legal writing. So use it at your own risk for that purpose.
Mhm.
But if we essentially force self-represented litigants who want to use AI to those non-legal tools, we're going to continue to see this type of output.
Right, right. And, there are tools for us, for judges, to check these things in a slightly more efficient way. So, for example, Westlaw has I think they've actually now broken it out into three parts, and there's one that's the judicial site check, right? They have this quick cite function, and it allows you to put the party's brief into the system, quickly check to see what cases are cited, do a side by side comparison. So, there are some tools for it. But it's not a total replacement for just being really, careful and reviewing the case sites very carefully and making sure that they're applied in the right context if it's a correct quote. And if it's not a correct quote or if it's a made up quote, then taking the next step. But there are some tools. And do you think that there is some added responsibility in terms of for us, right, for judges to just be checking this, knowing that especially pro se litigants, for example, are submitting this potentially submitting hallucinations?
Yes,
Yeah.
Quick Check is a great resource.
Yeah.
At our court, we now have a box that the clerks have to check before they submit the final version of an opinion. Have you run it through Quick Check?
Yeah.
And they have to check off the box.
Mm.
If they don't, it's not going to be announced.
Mm.
But we have to spread the word about these tools. So every Colorado state judge has access to Quick Check. We migrated to that, I think it was about a year ago. A friend of mine who's a state court judge, I won't name him, a trial court judge, said, gosh, if only there were a resource we could have where we could run, say, a self-represented litigant's brief through this tool and find out whether all the sites are good. I responded saying, I got some good news. You have it. All you have to do, and I showed him how to access it through Westlaw. He said, oh, I didn't know we had that.
That's a great point. I mean, there are so many tools, and every day, I mean, you mentioned earlier, ages ago in 2023, things are moving so fast. It does feel like 2023 was ages ago in this world. But every single day, there's more capability, there's new tools. And if we don't keep up with it, we may miss the opportunity to leverage AI, right? To either be more efficient or do our work better. So, another great reminder that sometimes the tool is out there. We just have to go looking for it and be really
Right.
thoughtful about it.
Right. And also, there's now a gap between the tools that at least the state judges have and the tools that the law firms have.
Mm,
The largest law firms have the financial resources
mhm.
to purchase these state of the art tools where they can upload their own firm files, they can upload the files in a case and ask the tool, draft a motion for summary judgment in this case, and then how would the other side likely respond?
Mhm.
We don't have those GAI tools at the state courts. They're expensive. I don't think we get a big discount.
Mhm.
Um, so
So,
lawyers the legal professionals are using those tools, but it's really hit or miss. Some of the smaller firms have them, some of the smaller firms don't. But there are a significant number of lawyers who have tools that I can only dream about.
yeah, I agree, and I actually think that that has the potential to increase our workload, right? Because as lawyers are making better use of these tools, and as pro se litigants are more comfortable with filings, right, and moving a case forward, I think there's the potential for our workload to increase. And if we're not leveraging these tools simultaneously and sort of, again, we don't have access to all of them, but to the ones that we do have, if we're not leveraging them efficiently, we may be outpaced, right, by the use that's happening out there in the legal profession. So I do have a little bit of concern around that we're not going to be fast enough. We're not going to keep up enough with how the legal profession is evolving.
And I think we judges just have to do the best we can with the tools we have.
Right.
You and I know that our respective judicial systems don't have the same resources that an international firm has.
Right. Absolutely. Absolutely. Um, Let's talk about submitting. So not necessarily just pleadings or briefs, but exhibits, right? Potentially evidence, and the sort of implications of AI in that world, and how should legal professionals be thinking about it when they are submitting something? And maybe it's not a hallucination, right? Maybe it's a totally appropriate document or exhibit that's being submitted, but that was created or somehow AI had a hand in generating that particular exhibit. How should lawyers be thinking about it? What duties come up in terms of duty of candor to the court? Do they have to tell the court every single time AI touches a particular exhibit that's being filed with the court? What do they need to be thinking about?
You're thinking along the right lines, and it may be up to the individual judge to decide whether the lawyers who practice before that trial judge are required to disclose whether an exhibit, whether an audio file, video file, still image was AI generated. Justice Maria Birkenkotter from our Supreme Court and I have spoken on AI at the last two state judicial conferences in Colorado. We're going to be speaking again this September. At the last one, a trial judge, at the conclusion of our presentation, raised her hand and said, "What do I do if I suspect an exhibit is AI generated?" Now, I'm an appellate judge. I have weeks to consider issues, to rule on issues. I have such respect for the trial judges who have to decide these evidentiary matters in a matter of seconds or minutes. So the question we got was, I'm a very busy trial judge with a very heavy docket. What do I do if I see an image that I think was AI generated? And she told a story. She asked a lawyer in a case involving domestic violence whether an image of the lawyer's client showing her face battered and bruised and cut, the judge asked, "Is it AI generated?" And the lawyer's response was, "Exhibit withdrawn." But we'll be talking about this further at this year's conference. The trial judges want to know, how can they tell if an exhibit was AI generated? And for a while we talked about watermarking, but now I see there are new tools that'll remove all the watermarks
Right.
from a document. This is getting really challenging. You certainly don't want a system where whenever there's an AI generated exhibit or any video file or still image file or audio file, each side has to put on experts to talk about whether it was or wasn't AI generated. And if it was AI generated, does it accurately depict what it purports to depict? I mean, can you imagine what would happen to our criminal justice system if in every criminal trial involving a body cam video, the two sides, the prosecutor, the defense lawyer, had to call experts on the veracity of this file?
Right.
And we're beginning to see what's called the liar's dividend, where some lawyers are beginning to challenge every video, telling the judge, oh, this must be AI generated. And then the judge has to make that decision.
Right. It's 100% agree. It's becoming, first, it's becoming, I think, top of mind for a lot of us, but also it's going to be increasingly difficult. I do appreciate the bench cards that were issued by, I think it's the Thomson Reuters and the National Center for State Courts partnership. I think they have a consortium, and they posted some bench cards. And I appreciate the framework they offered, which is acknowledged AI versus unacknowledged AI, right? And unacknowledged AI is really where kind of the crux of the problem is. But even on acknowledged AI, so a party says, this is AI generated. I'm doing this for demonstrative purposes, right? But I'm telling you up front, judge, that this was AI generated. So that's one camp and a different set of considerations versus the unacknowledged AI, which is a scenario you just pointed out, and that is, what if I suspect it's AI generated? And should I suspect that in every case where someone raises it? Because now we're, battling, the experts are battling every single time, and that's not efficient. It's a lot to think about, but some of these frameworks I find helpful because as a trial judge, you are having to think quickly, right? You are having to react quickly. And sometimes, frankly, I tell folks, you got to go with your gut a little bit.
Yes.
The one of the authors of these bench cards, or at least a contributor to these bench cards, Mara Grossman, who heads one of the working groups for the Sedona conference, used a 3-part framework for just kind of gut checking, right? The first is it too good to be true, right? Is the evidence just sort of too perfect for the situation? Number 2, is it something where, the explanation for, or the source is missing? The original source for this evidence is missing. And then 3, is the explanation just so complicated and so convoluted that you're sort of, tilting your head like, I'm not sure I follow. Those, 3, that 3-part sort of framework might help you gut check a little bit in a more organized way. But at the end of the day, it kind of does come down to how am I feeling about this, right? Does this look problematic?
Right, and I do plan to refer to the bench cards at this year's judicial conference. And as you may know, as many of the viewers may know, Maura Grossman has for years been one of the thought leaders on technology and the law. She was an e-discovery expert at the very early days of e-discovery.
Yeah, and she's got some great thoughts on this, and so I'm glad that she participated in those bench cards because I do find them helpful. Well, then let me just ask kind of the big question then before we wrap up, which is, if there was one thing that folks took away from this conversation, Judge Lipinsky, if there was just one thing you want them to keep in mind as they're thinking about evidence, which I know is hard because this is a big topic, but the one sort of pointer you want people to walk away with, what is it?
Put yourself in the judge's shoes and make the judge's job as easy as possible to get your evidence in. So obviously, lawyers have got to be forthright with the court. And if I were still in private practice and I very much wanted to get an AI exhibit in, I would tell the judge, at the time I'm moving for admission of the exhibit and I'm laying a foundation, I would explain how the exhibit was generated and why it should be admitted, why it accurately depicts what it purports to depict. Just like in the old days when we actually had photographs created by cameras, it's a little like that issue. The technology is so different. But ultimately, the question is this a fair and accurate representation of what it purports to represent?
With all that being said, thank you both for taking the time to discuss such a topical issue today. I think we all learned a lot about competency, confidentiality, and candor. Tongue twister there. But I appreciate understanding how that all impacts the rules and how we as attorneys should present to the tribunal and present to the judiciary. So thank you guys for listening, and thank you all for courting change with us.
I'd like to thank Judge Braswell, Judge Lipinsky, and Rabia for taking the time to speak with us today. AI may seem like it's changing everything about how lawyers work, but really, a lot of these ethical conundrums the judges talked about today aren't new. The need to fairly represent a client, to bill for services rendered, to provide competent representation. These have always been mandatory, just now with an AI twist. Thank you as